I am online. Please ask. Yes, I'm. Yes, 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 yes. Dr. Justice. Okay, now my voice is coming, sir.
Very much, very much.
Right. Thank you.
Shyam sir, if you could please turn on your camera for the purpose of testing.
How does this work?
Thank you, sir. Thank you. Thank you.
Okay, thank you.
Dedi, am I? Good afternoon, Shyam sir. Good afternoon, sir.
Good afternoon. Good afternoon.
Good afternoon. Good afternoon.
Sir, so Justice Muralidhar's office informed.
He has asked for a short Passover.
Yes, he'll be joining by 3.
I told him really that let it not be a Passover for the day.
So we'll start with the session.
Yes.
And he's been kind enough to intimate us that he'll be joining by 3.
I told him if you don't join by 3 o'clock, you will be virtually letting me down.
Yes, sir. So Ram, please take on to the mic.
An absolute privilege. Thank you, Siddharth, in the presence of our esteemed guests to introduce the topic. The topic today is strengthening doors of justice, augmenting accessing to virtual courts. Before the March of 2020, the idea of virtual courts did not create any interest, except perhaps as an academic issue. But today, as we lawyers grapple with a brief on one hand, a microphone on the other, stare at the computer screen and ask questions like, am I audible? Am I visible? And attend court matters sitting in our private spaces all around the country. Virtual courts, perhaps, is the most viable topic for discussion. To go to the various issues thrown open by the very idea of virtual courts would perhaps require the benefit of hindsight, as we see more and more of these issues sprouting up every day. Even though we are speaking of a contemporary issue, it would perhaps be interesting to remember a court anecdote from a pre-independence, pre-constitutional era. The anecdote goes like this. The then Honorable Chief Justice of the High Court of Sindh, Honorable Justice Godfrey Davis, because of the fact that the courtroom was jam-packed, suggested, why don't you close those doors? The lawyer famously retorted that the doors of justice shall never be closed. Around this famous retort contains most of the central issues relating to virtual courts. The issue of access to justice, the idea of an open courtroom, how open and transparent is a virtual courtroom? These are some of the issues which we see today. Judgments of the Honorable Supreme Court in Naresh Sridhar Mirajkar and Swapnil Tripathi emphasize the importance of transparency when it comes to judicial proceedings. The words of Jeremy Bentham, that there shall be no justice if there is no publicity around it, also echoes around these concepts. While the issue as to whether virtual courtroom would meet the criteria of an open court is open for debate, the issue of access is a much more practical one than one of jurisprudence. It is very difficult to speak of the question of access to justice without addressing the question of digital divide. While we are all proud that the Honorable Supreme Court started functioning through a virtual mode immediately after the COVID-19 pandemic took away the opportunity of conducting physical courts, while all the high courts today are equipped with the facilities to conduct virtual hearing, whether a vast, diverse country like India can be connected through online platforms, how safe are these platforms, whether the trial courts today are equipped with the level of infrastructure necessary to conduct virtual courts. These are some of the issues that are to be addressed. Whether digital divide takes away from the population, the access to justice remains to be a substantial question here. A parliamentary standing committee in its 103rd report recommended strengthening of virtual courts, even to the extent of suggesting that virtual courts could remain forever, at least as an option. The report suggests that virtual courts and e-filing are not mere reactions to the pandemic, but the future of increasing access to justice. While we look at other jurisdictions, the United States, the Singapore, the Turkey, Canada, and Italy have all embraced the idea of virtual courts in very many proportions. Apart from digital divide, I would, perhaps at the cost of being politically incorrect, introduce a subtopic called geographical hegemony of lawyers as a bigger challenge to creating greater access through virtual courts than even the challenge of digital divide. The lawyers practicing in a certain court would not want their monopoly or hegemony to be disturbed. And lawyers' associations naturally would oppose any idea that would challenge their monopoly, whether it be a new bench of a high court in a different place, or it be keeping virtual courts as an option. It's very interesting to remember that the opposition to the establishment of the Federal Court of India, which precedes the Supreme Court of India, did not come from the British, but from Indian lawyers practicing in the Privy Council. In a world where lawyers from every part of the country can appear before the Supreme Court, and the lawyers in the Supreme Court can appear in every part of the country, would it result in multiplicity of voices and provide us with a diverse bar, which does not distinguish between the appellate and the trial lawyer, and the trial and the transactional lawyer, is a positive thought that comes to my mind. And on that thought, I open this topic for debate.
Thank you, Sriram. It's my honor, my delightful privilege to introduce to the large number of people who are listening to us from various parts of the country, our esteemed panel today. That's my limited job, so I don't want to stand in between the panel, the topic, and our audience. Let me straight jump into it. There are 4 speakers that we have today. Of course, the presiding guest who will give the keynote address is Honorable Justice V. Subramanian, sitting judge of the Supreme Court of India. We are awaiting Honorable Justice S. Muralidhar as the guest of honor to join us. He has agreed to join us in a while. We have Mr. Neeraj Kishan Kaul and Mr. Shyam Diwan, 2 most distinguished go-to senior counsel in the capital city, who are also our co-panelists today. Briefly about each of our speakers. Honorable Justice P. Balasubramanian. He enrolled as an advocate in Madras in 1983, practiced primarily on the civil and constitutional side, with service matters as his area of specialization. He became an additional judge of the Madras High Court in 2006, became a permanent judge in 2009. In 2016, he was transferred to the High Court of Judicature at Hyderabad for Andhra Pradesh and Telangana. 2019, Pelot became the Chief Justice of the High Court of Himachal Pradesh. And at present, in 2019, he also became a judge of the Supreme Court, and presently is a judge of the Supreme Court of India. In anticipation of Justice Muralidhar joining us soon, let me also welcome him. Justice Muralidhar enrolled at the Madras Bar in 1985, soon shifted his practice to Delhi. First rank holder in LLB, first rank holder in LLM, first rank holder in the AOR exam, qualified chartered accountant, doctorate from the Delhi University. In his distinguished career, served pro bono in various matters touching upon human lives, including the Bhopal gas victims, the Narmada displaced, etc. Served as a counsel of the National Human Rights Commission, served as the counsel of the Election Commission, served as a member of the Law Commission of India. 2006, he was appointed as a judge of the Delhi High Court. He was transferred to the Punjab and Haryana High Court recently, and thereafter the Orissa High Court as the Chief Justice. I welcome him in anticipation of Justice Muralidhar joining us shortly. Mr. Neeraj Kishan Kaul is a very distinguished dear senior counsel. He obtained his LLB from the Delhi University. He obtained his LLM from the Cambridge, enrolled in the year 1987, became a senior counsel at a fairly young age of just 38 years. For a brief period, he was also on the bench of the Delhi High Court, which he relinquished and soon came back to private practice. He has served the country as the Additional Solicitor General, very distinguished jurist who regularly is invited to participate in various functions in and outside the country. Mr. Shyam Diwan, of course, very renowned senior counsel, started his practice in Bombay, soon shifted to Delhi, former president of the Bar Association of India. He serves as the vice president of Law Asia. He's also the co-chair at the Law Asia Human Rights section. He serves on the board of CARE India. He serves as a trustee at the Independent Public Spirited Media Foundation. He serves as a member of the governing body of the Center for Public Policy and Research. He serves as a member of the Consumer Education Research Center. And of course, he's a co-author of the famous book, Environmental Law and Policy in India. And often we see other pieces from him, be it in the field of PIL, be it in the field of constitutional law, biometrics, Aadhaar, etc., etc. With this brief introduction, I welcome this esteemed panel. We have, in fact, if we go by the registration, we have over 1,500 people who have registered for this event. I wholeheartedly welcome our esteemed panel to the first Justice H.R. Khanna Memorial National Symposium. And before we request Honorable Justice Ramasubramanian to take over, there is a short PowerPoint presentation on the CAN Foundation and its function. Immediately after that, we will request Honorable Justice Ramasubramanian to take the floor.
me have the honor of now inviting Honorable Justice Ramasubramanian. Before that, let me just take the liberty of telling our audience that Honorable Justice Ramasubramanian chaired the E-Committee in the Honorable High Court of Madras, and therefore, even before the question of virtual courts became this popular, he has been batting in that regard. Let me just call upon you, sir, to start.
Thank you, Mr. Sriram. My esteemed panelists, Mr. Neeraj Kishan Kaul and Mr. Shyam Diwan Singh advocates, Mr. Siddharth, Mr. Prashant, dear guests. Yeah, good afternoon to all of you. When I was informed by the organizers that Justice Muralidhar, Mr. Kaul and Mr. Diwan will be on the panel to talk about virtual courts, I was both relieved and tensed up. Relieved because I knew they will make up for my deficiencies, and tensed up because I thought I might end up making their task more difficult. At the High Court level, the judges across the country used to think of Justice Muralidhar as the Steve Jobs of the judiciary, as he switched over to paperless courts long before people like me realized that computers are not just typewriters. Therefore, with such a person on the panel, we could really look forward to a brainstorming session. Though the Indian judiciary conceptualized an e-courts project way back in 2005, when the National Policy and Action Plan for Implementation of Information and Communication Technology in the Indian judiciary was presented, and though the e-courts national portal was launched as early as in August 2013, it actually required a pandemic for us to explore the possibility of making courts virtual. As pointed out by Mr. Sriram, the 103rd Parliamentary Standing Committee on Personal Public Grievances, Law and Justice submitted an interim report on September 11, 2020, found the functioning of virtual courts, court proceedings through video conferencing. The report provided a definition of virtual courts to mean courts where plaint and other documents will be filed electronically, court fees could be paid electronically, evidence could be submitted digitally, arguments can be heard over video conferencing, and witnesses can give their testimony remotely over video conferencing, and the judges decide cases online, either presiding from the physical courtroom or from some other place. With a view to remove any misgivings, the report also indicated the difference between virtual and online courts. Many times we mistake one to be the other. But the report indicated that online courts are one step ahead of virtual courts. The only difference between virtual courts and online courts is that in the former, hearing is synchronous, but in the later, the hearing is asynchronous. This means that in virtual hearings, the judge, advocates, litigants, and witnesses need to be available at the time of hearing of a case. In contrast, in online courts, the participants need not be present simultaneously. Arguments, evidence, etc. are presented to the judge without the parties being together at the same time. According to the interim report of the Parliamentary Standing Committee, during the pre-COVID period, the VC setup was primarily used for conducting remand matters to prevent movement of prisoners between courts and jails. Such VC facilities have been operationalized between 3,240 court complexes in India and the corresponding 1,272 prisons. In fact, we were actually working on an application called Integrated Criminal Justice System, but for various reasons it could not take off, where we wanted to bring together on the same platform prisons, magistrate courts, and the police stations. But with the onset of COVID, the interim report recognized the need for legal sanctity to video conferencing. But the legal sanctity was already given by the Supreme Court by an order passed on 6th April 2020. The high courts were given the discretion to customize technology to suit their purpose. Model rules on video conferencing have been circulated. The district courts are to adopt the mode of video conferencing prescribed by the high courts. Interestingly, this report of the Parliamentary Standing Committee identifies three kinds of digital divide in our country. They are, number one, access divide, which relates to equipment and infrastructure. Number two, connectivity divide, which relates to broadband connectivity. And number three, skill divide, knowledge and skills required to use digital platforms. The report then recommends that certain category of cases can be permanently transferred to virtual courts. They are the Motor Vehicles Act cases, traffic challan cases, petty offences where summons can be issued under Section 206, cases registered under Section 138 of the Negotiable Instruments Act, and motor accident claims petition cases. But actually, India is not alone to have woken up after the pandemic. Many countries and even the United Nations Human Rights Council have realized the need to switch over from physical mode to virtual mode only after the COVID-19 struck. The UNHRC, in its 44th session, adopted a resolution on July 16, 2020. The preamble of this resolution expresses deep concern about the loss of life and livelihoods and the disruption to economies and societies caused by COVID-19 and about its negative impact on the enjoyment of human rights around the world. This resolution of the UNHRC notes with anguish the threats and the challenges posed by such extraordinary situations to justice systems, including with regard to access to justice. In this context, the UNHRC Resolution 44/9 urges states to ensure that judiciaries have the necessary resources and capacity to help to maintain functionality, accountability, transparency, and integrity, and to ensure due process and the continuity of judicial activities, including efficient access to justice, consistent with the right to a fair trial and other fundamental rights and freedoms during extraordinary situations such as COVID. This resolution also encourages states to make available to judiciaries current information and communications technology and innovative online solutions enabling digital connectivity to help to ensure access to justice. As I said earlier, India is not alone in its search for an online solution to an offline problem or a virtual solution to a physical problem a bit too late. The UK Parliament passed a law called Coronavirus Act 2020, which received royal assent on March 25, 2020. Apart from several other things, this act introduced several amendments to the provisions of various other laws, which includes the use and availability of live links during court hearings. Schedules 53 to 57, sections 53 to 57, read with schedules 23 to 27 of the Coronavirus Act 2020, amended civil and criminal laws, conferring powers on courts for regulating virtual court hearings, that is, prescribing eligibility restrictions. Courts have been conferred with the power to issue directions to persons participating in the proceedings for using live link. Courts can also rescind the permission at any time. Live audio proceedings can be conducted only when the proceedings fall under certain categories. Similarly, live video proceedings can be conducted only when the proceedings are of certain types. In USA, the Center for Legal and Court Technology at the College of William and Mary Law School, Virginia, has set up what is called McLaughlin Courtroom, which is considered as the world's most technologically advanced trial and appellate courtroom. It acts as a laboratory to experiment with various technological developments to constantly strive for better technological methods. The courts in Ireland use what is called PEPSIC Infinity. It is an application which provides an option to ensure that large numbers of personal injury cases, that is accident claims, assault, defamation, workplace accidents, etc., can be heard in a short term. 66% of the advocates and judges feel comfortable in Ireland with this application during the examination of witnesses, as the application does not allow any person to intervene as per their wish. They have enabled video link appearances from prisons for all people currently in custody. The unique feature of this PEPSIC Infinity is that participants could join a video conference session from other video streaming services, including Skype, Zoom, Cisco, and Teams, without the requirement that all parties use the same application. That is the speciality of this PEPSIC. But it appears that Russia and China are far more advanced. In Russia, all courts, prisons, and pre-trial detention centers are equipped with VC facility. In civil litigation, the consent of the parties is required. In criminal cases, the accused is normally heard in person in the court of first instance and by video conference on appeal. Currently, e-justice is provided through the corresponding subsystem of Justice SAS, State Automated System, along with MyArbiter, Data Bank of Commercial Cases, and Data Bank of Decisions of Commercial Courts information systems. They ensure e-document flow in criminal, civil, and commercial proceedings, creating a single information space for federal courts of general jurisdiction and commercial courts. The Russian court system has already demonstrated good results in implementing the electronic form of court document flow. A comprehensive service called Justice Online is also currently being developed. It will form the basis of a single information space for the courts and ensure accessibility and openness of justice. This service will be integrated with other information systems such as the State Services Cloud Platform, digital profiles, National Data Management System, etc. Coming to China, it follows a system called robo-justice, wherein the cases are decided by internet courts, which run 24/7 under China Global Television Network that does not require anyone to appear physically in the court. Hello, Justice Muralidhar, you can remove your mask.
Yeah.
You can be your original
So,
self.
yeah, sorry to be.
You can be your original self, I said.
Yes.
I was saying that China follows a system called robo-justice, where the cases are decided by internet courts, which run 24/7 under the China Global Television Network that does not require anyone to appear physically in the court. Smart court, they have a court called smart court. Probably they find people to man such courts. It follows, it includes non-human judges powered by artificial intelligence. People seeking legal action are supposed to register their case on the internet and resolve their matters via digital court hearing. The system gives users the chance to communicate and receive court decisions by text or through major messaging services. China's first internet court was established in the eastern city of Hangzhou in 2017, and it was reported in 2019 that users completed more than 3.1 million legal activities using the court system from March to October. The internet court in Hangzhou only deals with cases involving legal disputes over intellectual property, e-commerce, financial disputes relating to online conduct, loans acquired or performed online, domain name issues, property and civil rights cases involving the internet, product liability arising from online purchases, and certain administrative disputes. The Department of Science and Technology, in its research on robo-justice, titled The Rise of China's Internet Courts, gave an example on 11th December 2019, which goes as follows. The article says, the news report says, does the defendant, you ask a question, does the defendant have any objection to the nature of the judicial blockchain evidence submitted by the plaintiff? A virtual judge represented in the system by the image of a man wearing a black robe asks a pre-trial meeting. Then the human plaintiff replies, no objection. Blockchain now permits transaction records to be checked and stored safely. It links notary offices, forensic examination centers, and courts, making each unit an intersection. In Beijing, the average duration of a case is 40 days. The average dispositive hearing lasts 37 minutes. Almost 80% of the litigants before the Chinese internet courts are individuals and 20% corporate entities. Interestingly, the China's Supreme People's Court has been promoting a system called similar judgments in similar cases through artificial intelligence technology in order to ensure the effective supervision of trial activities. Prior to this, Chinese courts have long implemented the review and approval of judgment system, under which judges had to undergo review and approval by their superiors before rendering a judgment. In order to avoid it, SPC wanted a system of unified judgment while referring to a similar case system. This practice is called compulsorily similar cases search and reporting mechanism. Chinese courts have incorporated all the judgments throughout the country into a database and are now digitizing the case files, which will facilitate the judges' search. They have also developed what is called asynchronous court trial. Internet court has also developed an asynchronous trial mode where judges and parties can choose a different time to log in to the platform and complete the corresponding litigation process. The adoption of this mode requires the consent of all the parties concerned, and the final decision is of the judge. In Germany, virtual courts were introduced in 1998 for the protection of witnesses in criminal procedure. Under Section 128A of the Civil Procedure Code of Germany, similar regulations were introduced in administrative and family procedural courts. But consent of the parties is not legally required. There are certain special rules. In 2002, a legislation was introduced. Originally, the provision required that both parties consent to the use of video conferencing. Since 2013, the court can make an order under Section 128 A of ZPO, that is the German name for the Civil Procedure Code, allowing the use of video conferencing technology without the parties' consent, subject, however, to certain caveats. But COVID-19 crisis has triggered a discussion in Germany whether it would be permissible to exclude the public based on a public health perception. The question of consent of parties for participation in virtual court hearings has created certain problems in several jurisdictions. For example, a case came up before the Grand Chamber of the European Court of Human Rights. That was a case where in 2001, the applicant was convicted of murder and sentenced to a term of imprisonment in Russia. In 2002, the Supreme Court dismissed this appeal. In 2007, the Presidium of the Supreme Court granted a request for supervisory review, quashed the appeal decision, and remitted the case for fresh examination, finding that the applicant's right to legal assistance had been violated at the appeal hearing. This happened in Russia. In the new appeal proceedings, the applicant followed the hearing from a detention facility by video link, as the Supreme Court rejected his request to attend to it in person. Before the start of the hearing, he was introduced to his new legal aid counsel, who was actually present in the courtroom. And they were allowed 15 minutes of confidential communication by video link. The applicant attempted to refuse the assistance of the counsel on the ground that he had never met the lawyer in person. The Supreme Court rejected his objection to the counsel's assistance as unreasonable, noting that the applicant had not requested replacement counsel or leave to retain counsel privately. In a separate decision, the Supreme Court decided that it would not accept a new statement of appeal from the applicant and would consider his position on the basis of the previous hearing in 2002. On the same day, the Supreme Court examined the merits of the case and upheld the decision that was taken in 2001. This happened in Russia. But the Grand Chamber found that the applicant had been able to communicate with the lawyer only for 15 minutes immediately before the start of the hearing. Given the complexity and seriousness of the case, the time allotted had clearly not been sufficient for the applicant to discuss the case and make sure that the lawyer's knowledge of the case and legal position were appropriate. Moreover, the Grand Chamber felt that it was questionable whether the communication by video link had offered sufficient privacy. That was one issue flagged by the Grand Chamber of the European Human Rights Commission. But ultimately, they held that the review appeal, which was accorded to the applicant, was of no real assistance in removing the injustice done to him. So he succeeded before the Grand Chamber. Therefore, switching over to virtual courts is not actually without any issues. All of you must have seen a news item which appeared today in one online journal, I don't remember. The Advocate General of Jharkhand had made a request for a judge to recuse from a case on the ground that he overheard a conversation between the lawyer appearing on the opposite side with his client saying that he was 200% sure of success in this particular court. Therefore, the AG made a request for recusal. I don't know whether 200% success is assured because of the lawyer knowing the judge or lawyer knowing the mindset of the judge. It's possible both ways. But if we have a look at history, we will know that at some points of time in history, people went to courts. At some point of time in history, the courts came to the people. But today, technology has enabled the courts and litigants to remain wherever they are, and without any physical movement of any of the stakeholders, it is possible to administer justice. All of you know that the question as to how to make courts accessible to people does not have its genesis in the pandemic. This question has always bothered the rulers for several centuries. Henry II of England issued an act called Assizes of Clarendon in the year 1166, where the courts will move to towns. Therefore, people could no longer say, I will drag you to court, I will take you to court, because the court was coming to them. Today, neither the court goes to the people nor the people should go to court, because wherever they are, it can be operated. As an aside, before I conclude, I should tell all of you something very interesting. While I was in Hyderabad, I saw a state-of-the-art crematorium in Jubilee Hills, Hyderabad. While talking about, don't ask me why I talk about a crematorium while talking about courts. There's no connection. That crematorium is called Mahaprasthanam, which provides a Wi-Fi enabled viewing of the entire funeral process from any part of the world through live streaming. People who are stuck abroad and unable to come to India for performing the last rites of their near and dear ones watch the funeral online and can perhaps perform the rites digitally with the purohits appearing at the screen and chanting the mantras. Please do not think that I am making a comparison between the two, but I cannot help if your imagination runs riot. Before I conclude, I will just show you a video clip which runs for about 1 minute and 30 seconds. It should be screen shared. It's a very interesting clip about what happens at certain times in virtual hearings. Can Mr. Sriram allow me to screen share a video?
Yes, sir. We are asking our technical team right away. Just a minute.
Yes. Whoa, all of you are not technologically sound.
No, sir.
You need, all of us need assistance. I thought the organizers are better.
No, sir. There is actually a backroom technical team which is handling all these issues. We are on the screen.
All right.
So we have to ask them. Just 30 seconds they'll take.
Yes.
Sir, you have been made the co-host. So as co-host, you have the rights to share the screen now.
Yes. What should I do now?
There at the bottom of the screen, there is a...
Yes, I have pressed the button. Screen share, I have pressed the button. Post disabled participant screen sharing is what it says.
Just a minute.
What appears on my screen is a message saying post disabled participant screen sharing. So you enable me, that's all.
Yes, sir. We are trying to fix that. So please check now.
1 minute. Yes. Are you able to see?
I can't see.
No, I am not able to see it yet.
You're not able to see it? Just a minute. I'll again check. Now?
Yes, sir. Now it's coming.
Now it's coming? Yeah.
Yes, it's coming.
Okay. Yeah, have a close watch.
An unbelievable moment during an assault case that was being heard over Zoom. An attorney who thought the alleged victim was acting strangely asked a few questions, and it turned out the man accused of assaulting her was right there in the same apartment. Here's what happened next.
And I'm extremely scared for her safety.
It's the latest bizarre courtroom Zoom. A sharp-eyed prosecutor noticed something was off with this hearing for a man accused of assaulting his girlfriend.
The fact that she's looking off to the side, he's moving around. I want some confirmation that she is safe.
The defendant, Kobe Harris, has been ordered to stay away from his alleged victim. They're on separate Zooms, but the prosecutor believes they're actually right near each other.
Your Honor, I have reason to believe that the defendant is in the same apartment as the complaining witness right now.
Miss Lindsay, where are you right now?
I'm at a house.
What's the address? The defendant says he's at a different address, but the judge doesn't buy it.
All right, I want you to walk out to the front of the house, show me the house number on the house.
Police are called to the woman's home in Sturgis, Michigan. Turns out the suspicions are right. The defendant comes clean.
Your Honor, me and Mary both don't want there's no contact.
The prosecutor rubs her face in disbelief.
I'm sorry I lied to you. I knew the cops were outside. My advice is don't say anything else. Take the cigarette out of your mouth.
He's taken into custody. Other memorable pandemic courtroom Zooms include the lawyer who Zoom filter turned him into a cat. I'm here live. I'm not a cat. There was the surgeon who appeared on Zoom traffic court straight from the operating room. Available for trial by head. Nothing funny about a defendant sitting within inches of his alleged victim during his court hearing. Terry Austin is a legal analyst.
He's just making the case a whole lot harder for himself.
So that was it. Did you have a look?
Yes, we were able to view it. Very interesting.
You can remove the screen share.
So that has to be removed at your end.
Yeah, that's right. I am searching for you. I don't have a policeman to help me there. So that's it. Thank you very much.
So stop share is at the top.
Huh?
Stop sharing option must be at the top.
Oh yeah, okay. Yes. Now I have come back, yes.
Yes.
So I thank Khan Foundation for this opportunity to share a few thoughts. Now that Justice Muralidhar has come. Murali, I wanted to say, since I said it in the presence of others, not in your presence, I began my speech by saying that the judges of various high courts used to consider Justice Muralidhar as the Steve Jobs of the judiciary. That's how I began, but you were not here to listen to it. Thank you.
Thank you.
Thank you, sir. Thank you for such an insightful address on especially the international scenario with respect to virtual courts. I feel that virtual courts are something which must be encouraged, and especially at the High Court level and the subordinate court level. Supreme Court definitely is propagating that idea, but it has to be more from bottom to top approach than the top to bottom. With this, we proceed to the next panelist, the presiding guest of our session, Honorable Dr. Justice Muralidhar. Recently, sir, when we just asked, our team was searching for a profile, we came across a very interesting statement you made a few days back when Odisha High Court started live streaming of its court proceedings. Your Lordship said to all the subordinate judicial officer, the first class judicial magistrates, that look, we have to bring technology, we have to ensure that technology brings us closer to people and not makes us distant from them. Your Lordship's seasoned and exhorted all the judicial officers to ensure that there is maximum use of technology to ensure that there is a smooth dispensation of justice. Today, when we are in this session, we would like to request you to speak or put your views out as the Chief Justice of a High Court which heads a state, which deals with a state, 30% of which, whose area is a hilly, tribal, backward area. And when we talk of digital divide, when we talk of connectivity issues, as a Chief Justice, I'm sure you must be facing a lot of challenges and problems. There must be resistance from the bar when one talks about virtual hearing and all. But just to have a Chief Justice's take on all these issues and how to make virtual courts, how to strengthen the system, sir.
Very good afternoon to all of you. I'm very thankful to Justice Ramasubramanian for being so kind to accommodate me, my absence in the first part of this talk, although whatever he speaks is so enlightening. And I'm very glad to see Neeraj Kaul, Shyam Diwan, Ankit Swarup, Professor Saxena. It's almost I'm back in a room with all familiar faces. It's very reassuring. I want to start off with an aside, because Justice Ramasubramanian is great at asides. So what he and I could have done if we were physically in a panel is what I miss most today. We would have exchanged a glance. He would have nudged me and I would have nudged him. We would have had a snide remark. We would have just exchanged a joke. Now today I can't even meet his eye, right? So this is one of the first things which struck me, because it's such a delight to be in Justice Ramasubramanian's presence. The humor flows naturally and he puts you at ease completely. that aside, I think the relevance of this statement of mine is very important for what we are discussing. As judges, and I'm sure as lawyers in these last 1.5 years, that crucial eye contact that you make with a judge, that is what I'm told most lawyers miss. And as judges, I can tell you, we too miss that. Because whether the judges communicate or the lawyers communicate, a lot of things pass between a lawyer and a judge, which is unsaid, which could be by a look, by a shrug, by the body language itself. This essential part of a courtroom hearing cannot be replicated in a digital hearing. Likewise, when we talk of criminal trials or civil trials, a simple thing like watching the demeanor of a witness. How much ever you try and have a camera in front of the witness, if the witness is not looking at the lawyer into his eyes while answering a question, or the judge into the judge's eyes while answering a question, or refusing to meet the eye, there are very important pieces of communication which get missed out in a digital form, what you can get in the physical form. Which is why during the pandemic, one set of cases that have not progressed, and this we must very frankly talk about, are actually criminal trials and civil trials. So you asked me, Siddharth, about the scene in Orissa. So while we were able to have hearings in appeals, hearings in criminal revisions, civil revisions, final arguments in cases post-trial, the trials themselves have not progressed. Lawyers are for various reasons reluctant to conduct cross-examinations or examinations in chief in a virtual mode. I think they all feel comfortable if the witness is in the stand in the court. So I don't think they're anywhere close to replicating all that we do in the physical form in the digital form. But that is not to say that we can't use technology. We may not go the China way, we may not go the Germany way. I can tell you, I can share the experiences of Delhi. About 12 years ago, we had an experimental, a pilot project in the Karkarduma courts. One court was chosen, it was a court of the district and sessions judge. The sessions judge court was chosen for having cameras fitted. And it was just not a camera like the one we have now, just the webcam in front of us. There were cameras focused on the witness. There was one camera on the lawyer's side. There was one camera on the judge's side. And we connected the jail. We connected the forensic lab. So, and the police station. So we literally had an interconnectivity, the so-called Vision 3.0 that the E-Committee is talking about now, is precisely this, where you link up systems so that you don't need to move to the court. What Justice Ramasubramanian said, where you sit is where you're participating in the court. And what we found useful, and not useful, I will share with you, where we found it most useful was the official witnesses. We used a visualizer to show the witness in the forensic lab the test report and get his confirmation that this is the signature which he put on the test report and whether he stands by the test report. So there was no need for this man, even if he was in Ahmedabad or Mysore or Hyderabad, for him to travel to Karkarduma. So we could give him a slot. We could tell him that at 3 p.m. on a particular date, you better be ready before the camera in your office to answer questions. Likewise, the official witnesses, sometimes it could be a bureaucrat. In Delhi, you know, you have the Andaman Nicobar Union Territory, there's a cadre. So many Delhi officers get transferred to Port Blair and other union territories. So to come from Port Blair to Delhi just to appear in a case and go back meant 3 days gone or 4 days gone. This meant that you could give him a slot. He could appear from Port Blair in your court. So this was a big help that where official witnesses don't have to give up a whole working day. Like for instance, a doctor in a hospital. So we also had a facility of connectivity to the hospital, where an MLC was shown to the doctor and he was asked whether this, can you explain this or that? Where we found a problem was what again Justice Ramasubramanian highlighted in the Germany-Russia case. The lawyer could not consult his client. he could not get instructions from the client who's in jail. The client in jail, and this happens even in video remands, is in front of a camera, but he's not isolated. The jail warder is there, the jail staff is there. He's not free to speak. If he's going to come on a video and instruct his lawyer as to this particular witness who's in the stand who has to be cross-examined, the prosecution witness, he can't do it unless all the conversation, which is actually a privileged communication between the lawyer and the client, is made public. So it defeats the purpose of the Evidence Act. So one way we thought of overcoming this was to have a hotline. There will be a glass kind of a cage for the lawyer, for the defense to walk into, pick up the phone, talk to the accused or the defendant in the jail on the other side, and have a conversation with them. But this again, there's no guarantee that this conversation cannot be overheard. Now, this is a very, very important part of a criminal trial, within the digital mode will not work. So this is one problem we ran into. We didn't have an adequate answer for this very critical phase of a criminal trial. Second, in the reality of Indian system, while it is fine to say, let's have video remarks, and most courts in India have video remarks, even Orissa courts have video remarks, which avoids the prisoner having been being brought to the jail to appear. But there's an important aspect here, which is when the prisoner is kept in the court lockup, that is an important opportunity for his relatives to visit him. And it's a very important, there are so many communications, that take place between the relatives and the prisoner. It could be about a daughter's marriage, it could be somebody's loan that has to be repaid, some very personal matter. Of every time the family relative has to go to the jail, wait for a pass, go and meet the person in the jail, again in the midst of a whole huge hall with everyone shouting. So this was missed. This opportunity of meeting the prisoner in the lockup was missed. And this prisoners have shared with the court, saying that how they missed this because of the video remand. Third, when you come to the civil jurisdiction, in the Delhi High Court, you will all remember that we had paperless courts. So we were pushing to use technology to avoid the time period of service of notice. If you find 80% of adjournments in our civil courts is because service is not come. It's a very irritating factor. It is also a factor in the high courts. It's equally, I'm sure Justice Ramsubramanian will now vouch for it, a factor in the Supreme Court. The turnaround time for an SLP is 1 year. Again, all taken for service of notice. We tried to see how we can minimize this gap. So we talked to the postal authority in Delhi, the speed post service, and we told them, can you put all your tracking reports online so that our officer in the court can access it? They agreed. Where we ran into a problem was this. Delhi is fine, Metropolis is fine. There are many places not served by speed post. There are many places in India not served by courier service. We still have to rely on the traditional old registered post. We haven't found a way of digitizing this entire phase of service of notice. The other important point of service of notice in the electronic form is the confidentiality attached to the papers. Let's take a matrimonial case. It's a divorce matter. The wife has made all kinds of allegations about the husband or vice versa. And this has to be served on the opposite party. Today, what happens in the physical form is I file a process fee. I file the covers. The petition is put into the cover is sealed. Even the process server or even the postman takes a sealed cover and delivers it to the defendant. So nobody reads it except the defendant. Now try and visualize this in the digital form. How will it happen? It just can't happen. If I send it to you by email and send it to you by email attachment, still it is only an attachment to the file. Okay, you say, let us make the attachment password protect. If the defendant is in a remote village which has no email connection, or the defendant doesn't have an email account, what happens? Question number one. Question number two, the defendant says, I don't want to read this online. I want to read it in a physical form. We then asked ourselves, can it go to a post office where the postman will download it, put it in a packet and deliver it to the opposite party? Again, the postman is going to read it. we found internationally they haven't solved this problem. So going completely digital is still a distant possibility. But having digitization in certain phases of a case, in certain kinds of cases, where both the plaintiff and the other parties are completely technically savvy, where the connectivity is good, it can work very well. Today, in the Orissa High Court, I've inaugurated training for lawyers in use of e-services. I find that while judges have gone ahead in the digital mode, the lawyers are yet to catch up. And this is a fact. Most lawyers, and I'm not sure between Shyam and Neeraj, if the thoughts flow only when you hold the paper. Many senior lawyers have told me, I need the brief in my hand. I can't look at a tablet and argue. I know Dr. Singhvi does that. Dr. Singhvi looks at the tablet and argues. Justice Sanjeev Sachdeva, when he was a lawyer, he was a senior lawyer in the Delhi High Court, he would always walk into the court with his iPad. And he took to the whole thing like fish to water, and he would argue all his cases with the iPad. Some very elderly lawyers were using the iPad. Some very young lawyers were reluctant to do that. So this has nothing to do with age. It's about the comfort level. I am told many lawyers do file still comfort in only the physical paper. When the pen touches the paper is when the thoughts flow. I'm told many writers also need that tip of the pen to touch the paper. Justice Ramasubramanian is a big writer, and he'll vouch for it. Many of the thoughts simply don't flow till pen touches paper. I don't know how Professor Saxena, what she does. So there are some things peculiar to actual physical functioning, the physical world, which we cannot replicate in the digital world. So my sense, my final take on all of this is, although I have adopted technology in a big way, I have done the paperless court. I'm trying to do the paperless court in Orissa here too. And I'm egging lawyers on to use the e-filing techniques. I think it's a big help if we can go to e-filing, if we can go to online filing, if we can minimize paper in court, at least minimize on the judge's side. But my sense is we can't replicate every step of the process. And perhaps we shouldn't. I think this is a technology. We should use it to the best possible manner, as many phases as possible. But we can't replace what we do physically with what we are doing digitally. And it should remain that. I think there should be some aspects of the court functioning which should remain physical and some other aspects which can go digital. But there's a huge potential. There's a lot of learning, and the possibilities are limitless. So with these remarks, I thank all of you for letting me participate. And I once again apologize for not being able to stay the whole course because I have to go back to a hearing. Thank you. Thank you so much.
We are thankful to Justice Muralidhar for having shared his views on how we miss in-person interaction in virtual courts and how it has an effect on justice delivery system. And he has also spoke on how best to overcome these difficulties. We are grateful to you, sir. We also have amongst us Senior Counsel, Mr. Neeraj Kishan Kaul. He needs no introduction. Sir, he has been appearing before all courts, and now also he is appearing before all virtual courts across the country. He appears and he argues before all high courts and tribunals and Supreme Court. Sir, what are your views on adaptation of virtual courts in our countries? Sir, kindly share your views on it.
Honorable Justice Ram Subramanian, Justice Muralidhar, esteemed members of the CAN Foundation, my very dear friend and colleague Shyam, and dear guests. Before I share my views, someone last night, Justice Subramanian, especially for you, I must share this. Someone last night, a very esteemed senior counsel, told me that one early morning, while another senior counsel was inquiring from the control room in one of the courts in Supreme Court, saying that, am I audible and visible, which is pretty much now for all of us, the routine every morning. So the moment he said, am I audible and visible, came the voice from the other side of another senior counsel, not only are you audible and visible, you're incorrigible. So those are the lighter moments of virtual hearings. But coming back to the need, COVID-19 induced lockdown of courts has given a flavor. of the potential that technology holds to address a key concern, access to judicial system and thereby justice. Unlike just a few months ago, the thought of virtual courts in India dispensing justice and aiding dispensation of justice no longer seems far-fetched. If anything, the pandemic has forced us to fast-track the adoption of technology for good. Virtual courts is not a new concept for the Indian judiciary. The e-courts project was conceptualized on the basis of National Policy and Action Plan for implementation of information and communications technology in the judiciary in 2005, submitted by the E-Committee of Supreme Court of India with a vision to transform the Indian judiciary by ICT enablement of courts. On 7th of August 2013, Honorable the Chief Justice of India launched the e-courts national portal, ecourts.government.in of the e-courts projects. More than 2,852 district and taluka courts complexes have secured their presence on the National Judicial Data Grid and portal and are providing case status, cause lists online, and many of them also uploading orders and judgments. Justice D.Y. Chandrachud, in his dissenting opinion in Santani versus Vijaya Venkatesh, favored the use of technology and video conferencing and highlighted the pros of video conferencing. Pertinently, this decision was rendered in the pre-pandemic era. In 2018, the Supreme Court held in Sapnil Tripaঠি's case espoused the benefits of adopting technology in the judicial system, particularly live streaming of court proceedings, highlighting the potential tangible and intangible benefits to stakeholders, especially litigants. The courts had observed that technology could epitomize transparency, good governance and accountability, and more importantly, open the vista of courtrooms, transcending the four walls of the rooms to accommodate a large number of viewers to witness the live court proceedings. This threw light on another aspect of virtual courts, open court and justice delivery system. There are also the benefits of modern artificial intelligence tools that will assist in improving the efficiency of our justice system through sophisticated and contextual automation of existing repetitive non-judicial tasks and functions to reduce pendency, expedite judicial adjudication, and create more time for judges to resolve complex cases. With a surge in internet users who constitute 34.8% of the population of 462 million people in 2016, the idea of virtual courts is more viable now than ever before. This current pandemic, unfortunate as it is, has given the much needed momentum to take ICT integration in the judiciary towards ambitious vision. Litigants need not leave their work to attend court as they can access proceedings from home or office. It facilitates a lawyer to argue in any court in India. A lawyer can argue in one court in the morning and be present in another later in the day. Virtual courts will promote access to justice since litigants in remote areas now have the means and tools to approach courts without traveling far off distances. They can also engage a lawyer of their own choice for any part of the country instead of being constrained by force by regional choices. Currently, due to suspension of physical hearings in the courts, a lot of matters are stuck at the stage of evidence in trial courts. A nationwide standard mechanism needs to be devised in order to equip trial courts to record evidence through video conferencing. Recording of evidence through video conferencing has been held to be an acceptable mode of recording by the Supreme Court. In state of Maharashtra versus Praful P. Desai, it was held that evidence can be both oral and documentary, and electronic records can be produced as evidence. This would include video conferencing. The Supreme Court went on to observe that recording of evidence by video conferencing also satisfies the object of CRPC, that evidence be recorded in the presence of the accused. The accused and his pleader can see the witness as clearly as if the witness was actually sitting before them. Further, in addition to recording of evidence, the examination of accused persons under Section 313 of the CRPC can also be carried out by VC questionnaire, at least in summons tribal cases, in view of the spirit of judgments of Supreme Court in Prafulla P. Desai versus State of Maharashtra and Basava Raj Patil versus State of Karnataka. In that case, it was held that if the accused satisfies the court that he is unable to reach the venue of the court except by bearing huge expenditure, or that he is unable to travel the long journey due to physical incapacity or some other hardship, the court should relieve him of such hardship and at the same time adopt a measure to comply with the requirements of Section 313 of the court in a substantial manner. The Delhi High Court has framed VC rules, which also contain a chapter on recording of evidence. As per these rules, there is a concept of remote point, required person, and coordinator. Therefore, as per VC rules, the court's designated coordinator is required to be deployed at the remote point from where the evidence of the witness is required to be recorded. The role of the coordinator is to ensure that the witness answers all the questions through VC without any prompting, undue influence, coercion, etc. However, no SOP or directions have been released by the High Court yet in relation to the procedure to be adopted while appointing a coordinator. Further, in the case of witnesses who reside outside the state, there is a need to formulate a standard SOP according to which a judge from one state can request the district judge of the concerned state to appoint a coordinator in the particular state and send him to remote point in that state. Current physical communication channels between different state judiciaries are not swift enough to address this concern. A nationwide electronic mechanism needs to be developed so that the communication for appointment of a coordinator can be received from one state to another on a swift basis. Coming back to the normal functioning of the courts through VC, there is a need to explore the possibility of hybrid functioning, that is the option to appear physically as well as through VC, to ensure that even when the courts start functioning physically, advocates parties which are vulnerable, like senior citizens, can appear through VC. However, when a matter is taken up through hybrid mode, both the counsels appearing physically and virtually are not able to hear each other clearly, which results in slowing down the court work. In order to resolve this issue, the possibility of installing mics in all courts may be explored to increase the audio volume. In district courts, Wi-Fi or LAN connection in the court premises would make for a better court experience for the litigants and lawyers. Currently, judges in trial courts are conducting VC through 4G connections with hotspot, which creates a lot of connectivity issues and makes it difficult to conduct court proceedings smoothly. Work from home for court staff can be fully operationalized by distribution of computer systems to staff members. Right now, staff members working from home, though available on the call, are only able to render limited assistance owing to lack of computer systems, at least in the trial courts. This would allow the court to function full throttle while simultaneously reducing the number of staff members physically present in the court on any given day. One of the biggest hurdles being faced during the virtual hearings is that of poor digital connectivity. In view of the pandemic, courts are hearing cases online. Standard operating procedures have been put in place for e-filing, mentioning, listing, and hearing of matters through video conferencing, teleconferencing mode. There have been some instances where the hearings have suffered due to technical glitches, especially during peak hours, when many people log into the video conferencing system and how it often crashes. We have gained from the experience and should work to address this issue. There is also a need for legislative backing for the temporary and long-term measures being taken by the judiciary towards establishment of virtual courts. In addition to amending the necessary existing laws, an overarching legislation must also be enacted to sanction virtual courts. The concept of open court is covered in the Constitution of India under Article 145, Subclause 4, Section 327 of the Code of Criminal Procedure, and Section 153B of the Code of Civil Procedure. The introduction of virtual courts has been held synonymous with increased accessibility. However, they presume a familiarity with access to technology in its various forms. Further, the lack of reliable high-speed internet continues to work as a barrier for a significant proportion of the Indian population. Access to internet does not ensure access to all forms of technological solutions that are on offer. Familiarity with a digital vocabulary and skills required for utilizing its associated technology are gained through repeated interactions, leading to familiarity in dealing with services offered online. To ensure further inclusive access is also important for such tools to comply with the accessibility norms under the Right of Persons with Disabilities Act 2016 and cater to the requirements of linguistic minorities. Additionally, we cannot lose sight of the fact that to make such drastic technological advancements, there has to be exhaustive digital literacy and training of all judicial officers, advocates, and other court staff, including those in charge of filing and presenting files before the appropriate court. It is too far-fetched to imagine that every person involved in the justice system at all levels will be able to learn by themselves and adopt to the new medium within days or weeks. There is a Parliamentary Standing Committee report which has opined that digital divide has three dimensions, namely access divide, access to equipment and infrastructure, connectivity divide, access to broadband connectivity, and skill divide, knowledge and skills required to use digital platforms. E-Seva cranes have been established in all high courts and in one district court in each state as a part of pilot project to provide assistance to lawyers and litigants ranging from information to facilitation and e-filing. E-Seva cranes will go a long way in bridging the access divide and such facilitation centers to set up in all courts complexes across the country at the earliest. The Ministry of Communication should also step up efforts to ensure timely implementation of the National Broadband Mission, which envisages broadband access to all, so that services provided by indigenous communication satellites are fully harnessed and the goal of universal broadband access is achieved. Before I conclude, some concerns, because as Justice Muralidhar rightly pointed out, of course, digital technology, virtual courts are there to stay. They must supplement and can't supplant physical hearings. And some of the concerns are, for instance, while recording evidence, the court is also required to record the demeanor of a witness. If evidence is being recorded through VC, it becomes difficult for the court to observe the demeanor of a witness and record it properly. Another instance is that a large portion of population is not well versed with technology, especially financially weak and illiterate citizens. It is unfair to direct and expect indigent litigants to appear from a court hearing through VC. The doors of justice must be open physically for such litigants to effectively fight their case. Also, another instance is whenever an accused is arrested in a criminal case, he is required to be produced before the area magistrate within 24 hours. Under Indian law, such production is required to be made physically and must continue to remain that way to ensure that the accused is able to speak freely before the judge in case he has any complaints. Production through VC can lead to instances where accused is prevented from speaking freely by the police force. There are also instructions on the clients which have a material bearing, and especially becomes extremely important in a criminal case where an accused is being produced from judicial custody. In a VC setup, the advocate is not able to interact at all with the accused, as opposed to a physical courtroom where the advocate would be able to interact with his clients easily while arguing his case. Another area which Justice Muralidhar rightly touched upon was the personal touch by way of the counsel and the bench, which being an immediate vicinity during the hearing plays an important role. At times, the counsels gauge the body language of the judges, a few whispers here and there. The judges also observe the body language of the counsel. Sometimes a point is made more emphatically just to drive home the gravity of the same. This, to a large extent, is missing during and is restrained during a virtual hearing. It may also be difficult to conduct complex matters on the original side as well as the appellate side solely through VC. With voluminous records, pleadings, and complex factual matrix, as well as structure, a physical hearing is much more efficient and effective in a number of cases, both in terms of time and courts. And more importantly, right now, law graduates fresh out of law colleges and other associate lawyers miss out on observing hearings in court, court craft, the hustle and bustle of courts, submissions of the lawyers, which are crisp, clinical queries by the bench, etc. And this, to a great extent, does denude them of a great learning opportunity, which was easily available during the physical courts. To conclude, as Justice Benjamin Cardozo had said, new times demand new measures and new men in the field of law or elsewhere. The statement today is very much relevant to the current situation. The fast-track adoption of technology has been a blessing in disguise for the justice delivery system of this country. Virtual courts and hearing cases through video conferencing have gained immense ground during the pandemic and will remain a new reality and new normal. The courts, more than ever before, need to invest heavily in the development of technological facilities and infrastructure. Access to justice needs to be reimagined, but definitely at the end, I'll re-emphasize, there cannot be a substitute for physical hearings. And putting pen to paper, personally speaking, I think Shyam is far more technologically advanced. For me, putting pen to paper is still very important. And I conclude with that.
Thank you, Neeraj sir. That was insightful and humorously delightful at the same time. It was a pleasure to listen to you, sir. Now, before I invite Shyam Diwan sir, I would wish to tell the audience that I can bravely make a statement that Shyam sir epitomizes virtually everything relating to data privacy, technology law, etc., for lawyers in the Supreme Court and connoisseurs of law all around the country. And therefore, I think the audience is extremely keen to listen to what Shyam sir would want to say about the topic.
Thanks very much, Sriram. Justice Ramasubramaniam, the virtual avatar of my dear friend Justice Muralidhar, my dear friend and colleague at the bar, Neeraj Kaul, Siddharth, Professor Poonam Saxena, Professor Shanta Kumar, Ankit, ladies and gentlemen. Thank you very, very much for this opportunity. And I want to begin by commending the Khan Foundation, as well as the Gujarat National Law University and the National Law University of Jodhpur for organizing this symposium and dedicating it to the memory of one of our finest judges, Justice H.R. Khanna. I think the very fact that you've organized this event and that you have dedicated to him, you've named it after him, is, I think, an affirmation of the high values which he stood for, most important of which, I think, is constitutional courage. And I commend you for that. I think it's an extremely important value system that you have projected through holding this symposium and seminar. I also thank you for this opportunity, for allowing me to participate on this panel. It's a special privilege to have Justice Ramasubramanian on this panel and to be comforted and reassured that what I submit today will not be dismissed out of hand, as is often the case. I also would like to begin actually with a small reference, and I want to quote from a voice of a senior advocate who was present during ADM Jabalpur. I had the privilege of meeting Justice H.R. Khanna just once, and I remember that very clearly. It was well past his retirement, of course, and I had come across from Delhi, and my father took me across and said, "This is the famous Justice H.R. Khanna." And it, left an indelible impression on my mind. You heard in the earlier session this morning a reference by Mr. Narasimha to Palkhiwala on H.R. Khanna. And I remember very, very clearly, so this must have been, I suppose, January or February 1977. I was in school at that time. It was at the bottom part, and I pretty much think it was in the Indian Express. It was on the first page. And Nani Palkhiwala on the resignation of Justice H.R. Khanna had written a tribute to him. And it had appeared at the bottom, at least of the Bombay edition of the Indian Express and the foot. And it came back to me. He was, of course, very dismissive and extremely humble, etc. But I want to read from an account that my father wrote in a chapter in a tribute to him. It's titled Cry Freedom. And I read this short little excerpt from On the Front Foot. And I begin the quote. A bench of 5 judges of the Supreme Court, Chief Justice Ray, Khanna, Beg, Y.V. Chandrachud, P.N. Bhagwati, heard what was known to be, the case that was known as the habeas corpus case, ADM Jabalpur. The only question before the court was whether the petition for habeas corpus and other similar petitions under Article 226 were maintainable, notwithstanding the suspension of fundamental rights on the ground that the order was beyond the statute or were issued mala fide and were not in accordance with law. Shanti Bhushan led the argument. Ram Jethmalani, Soli Sorabji and I from Bombay came from Bombay to argue for various detainees. N.M. Ghatate was actively in the fray. We thought our case unanswerable. With 9 high courts in our favor, we were grievously wrong. On April 28, 1976, 4 judges decided in favor of the government, holding that the petitions were not maintainable. Justice Khanna was the lone dissenter. The argument which was accepted by the majority was that even if a person is tortured or deprived of his property, his wife is spirited away, or members of his family are detained or harassed without legal authority or mala fide, there was no remedy and the court's doors were closed. This was a complete negation of the rule of law, which means that no government officer can act against a citizen or his property unless authorized by some law or rule. Justice Khanna in his autobiography writes about the habeas corpus case graphically. He says, in view of his Attorney General Day's submission, would there be any remedy if a police officer, because of personal enmity, killed another man? The answer of Mr. Day, Attorney General, was unequivocal. Consistently with my argument, he said, there would be no judicial remedy in such a case as long as the emergency lasts. His dissent rejecting the Attorney General's argument held the petitions maintainable. It was the only light in an atmosphere of total gloom. But the reaction in other democratic countries was heartening. The New York Times on April 30th, 1976, came out with an editorial which has become classic and is cherished by many of us who lived through those dark days. And I quote now the New York Times editorial. If India ever finds its way back to the freedom and democracy that were proud hallmarks of its first 18 years as an independent nation, someone will surely erect a monument to Justice H.R. Khanna of the Supreme Court. It was Justice Khanna who spoke out fearlessly and eloquently for freedom this week, and dissenting from the court's decision upholding the right of Prime Minister Indira Gandhi's government to imprison political opponents at will and without court hearings. The submission of an independent judiciary to absolutist government is virtually the last step in the destruction of democratic society, and the Indian Supreme Court's decision appears close to utter surrender. And I end the quotation. The bar, and I speak to the young audience over here, is an excellent judge of our justices in the Supreme Court. And we have in courtroom 2, which was the last court in which Justice Khanna sat, a special portrait of Justice Khanna, which adorns that court and which gazes down on counsel. And this was put up because of the request of members of the Supreme Court bar. So we have a monument in that form, and it's a living monument, and it's an extraordinary reassurance when each one of us as counsel is presenting cases in that court to have the encouraging gaze of Justice Khanna to assist us, because we know what this the Supreme Court as an institution is capable of. And I think we can use this opportunity also to acknowledge that we get great judges from across the country from time to time to adorn our Supreme Court. It's an institution worth fighting for and worth preserving. And I think in the retirement, just a couple of day before, of Justice Rohington Nariman, again, we have lost one of our great justices. But quite apart from missing the gaze of Justice Khanna from the portrait in courtroom 2 in the Supreme Court, let me just touch upon a few issues which will complement or supplement really what was mentioned by Justice Ramasubramanian, Justice Muralidhar, and my good friend Neeraj. I thought the first point I would make is that we have to perhaps look at virtual courts in the context of a larger transforming technology. So it's not just the pandemic, But let's try and examine this from the standpoint that we now have huge pressures and changes in technology which are taking place even after the pandemic abates, which are going to result in each one of us re-examining our roles. For example, in Justice Ramasubramanian's example of the robo-courts in China, it's a value system. Do we want robotic justice? Does the Constitution allow that? Because there's a lot which can be attained in terms of access to justice through that means. And let me just build on the example which Justice Ramasubramanian mentioned. In certain societies in China, I believe is the leading example. Just as you have an ATM, which we take for granted, an automatic teller from which you can withdraw money, virtually a kiosk, you have justice delivery kiosks operating on AI across China, including rural areas. And a huge number of disputes are being solved today, petty, minor, even sometimes major, with regard to property. We heard the example of intellectual property, for example, disputes which you may have with a government official. And you have a statistical response through AI about your chances of success. The judges are being guided by, as we were told, about precedents, etc. But just imagine how cheap this is, how much it improves and allows access to justice. It's another matter as to what impact it is going to have to us members of the bar. But from an access to justice point of view, this is a remarkable measure. It's like, it's like a revolution, like our consumer courts. When our Consumer Protection Act came, I mean, there was a whole range of disputes and grievances which society had, which they could never otherwise seek redress in respect of. And now you have this forum with all its imperfections. It still relieved and enabled access to justice and relieved a sense of injustice which was being harbored by segments of our society, which we had perhaps even not learned to articulate until we now know about consumer rights. So this is one of the great advantages of having huge technological changes, AI coming into the picture, and increasing, therefore, access to justice. So I would suggest that let's not look at virtual courts only from the standpoint of these video screens, etc. Let's also consider it from a larger perspective of sweeping technological changes. These are changes, for example, take the leading medical schools across the world. The most prestigious, as you recall, area was surgery in medical schools. And now all of a sudden, the top medical schools are changing their curriculum to teach medical doctors who opt for surgery advanced robotics, because they know that it's going to be much quicker. It's already happening, of course, but it's essentially the human agency is going to be so limited insofar as your robotic surgeries are concerned, that's going to work. That's likely to be a norm in as little as a decade from now. So I would suggest that we look at it from this broader concept. The second set of supplementary points I'd like to make are in the notion, again, of access to justice from the standpoint of the litigant. And I think there's no doubt that in terms of economy, if we look at it from an economical or financial perspective, virtual courts and this whole new technology which is being deployed ought to make it a lot cheaper, the access to justice to the end of the day. And I believe any such type of efficiency ought to be encouraged. And therefore, that is an enormous plus in terms of virtual courts and all the paraphernalia which we associate with virtual courts. I think there is a problem, and I think that problem has been already noticed by Justice, especially highlighted by Justice Muralidhar. Neeraj Kaul also mentioned it with regard to aspects of confidentiality. And I think in many cases which are both non-litigation in terms of what lawyers do when we're negotiating contracts, when we're negotiating positions. I think confidentiality is very, very high in many situations, as I understand it. Entrusting a work to a lawyer also involves that. And somehow I feel those kind of activities, this is just a supplementary point in terms of briefing, in terms of engaging with your lawyer. I somehow feel that we're not quite as at ease through this virtual space of dealing with situations like that. As far as the digital divide is concerned, I want to make a couple of points. The first point, I want to challenge Justice Muralidhar. Unfortunately, he's not here. But I fully agree with him on the point that in several courts, and I mean, I really salute the courts, for example, where he has acted. I salute also the Supreme Court and the manner in which the judges have adapted to this new technology. But it is not a uniform experience across the country. Even in our constitutional courts, we find that there is tremendous resistance from a large number, I'm sorry to say, of honorable judges as well. It may be because of fear of the technology. It may be other factors where people are reluctant. But it is not, the point I'm making is it's not the bar alone and segments of the bar which are resistant to this change. You will find that resistance to change also at some elements in the judiciary. I think on digital divide, the supplementary point I wish to make is I see a huge role and potential for our bar associations. I think our bar associations must come forward and assist in the bridging of this digital divide. Justice Muralidhar mentioned, for example, that there are all sorts of now courses, etc., for our judges. There are courses, etc., for judicial officers and registries, etc., to equip them, to train them. I think in terms of outreach on all those points which were mentioned, outreach with regard to both the devices and the infrastructure on the one hand. Justice Ramasubramanian mentioned that there was a connectivity issue, which was the second bucket in which this fell. And then, of course, the skill element, which he also pointed out. So for all three dimensions, I think the bar associations and probably organizations like the Khanna Foundation as well have a responsibility and a duty to ensure that access to justice is supplemented, is enhanced, maybe in our bar association rooms, maybe across the country, maybe a few pilot positions, and then an outreach so that our colleagues at the bar are also not disadvantaged and their clients in turn are not disadvantaged. So I see a role, I believe, for bar associations to step forward. The third point in terms of supplementary points that I thought I'd make is we've gone access to justice. I made a few in terms of from the standpoint of the litigant. Now, from the standpoint of the lawyer, and here, I mean, I wish we could have a sort of a question and answer session here, because I'd be very interested in knowing the responses. But to me, our profession, for crores of people, for, across the country, because not just the lawyers I'm talking about the entire family around a lawyer. The BA, the LLB degree, the fact that you wear a black coat and that you go to work in a court and you sit in the courtroom supplies an enormous amount of dignity. It not only supplies dignity in our culture, in our societal milieu, it also gives you, along with that, status in society. And I am not sure the time has come when we can all of a sudden shift to virtual courts, not be in courtrooms, and deprive so many of our brethren at the bar. I'm talking about the bar. This is not just the senior bar. It's also about the junior bar. It's very importantly about the junior bar. I think a lot of the learning which all of us do is not in law college alone, good as those colleges are, but it's from learning from how others argue, learning, I think, most important on how not to argue and how not to put forward your case. But all that learning often happens subconsciously through a system of open hearing. And here I had the advantage of, bouncing off my colleagues Sudipto Sarkar and Shreyas Lalit just before this session, because I had a point of view and they gave me some interesting perspectives. They said that, look, the Supreme Court just now functioning is very limited. But there are many high courts now which are using limited in the sense in terms of access, who can come into the courtroom and who can see who's arguing. But there are a large number of other high courts which have adopted platforms where anyone and everyone can come in and see in terms of how cases are being presented. So I was more familiar with the Supreme Court thing where, there is a cap in terms of, or a technical limitation on how many people they can hear in a courtroom. But I'm told that there are other platforms which are adopted. That might, to some extent, alleviate this problem. But I think otherwise, open justice, of course, most important from the standpoint of what is happening in an individual case. But in terms of just training the next generation of lawyers, I think our lawyers have to have the access. The young bar has to have an access. The senior bar and the stalwarts have to have that element of dignity. And that is why I liked Justice Muralidhar's point about saying that, look, maybe we can't make an overnight and immediate transition. Maybe it should be a transition in a phased manner. And I like that suggestion. I think we should work towards that. I have another point, and I hope this is not a case of sour grapes. But the point I wish to make is that we cannot operate now on, what are they called? SOP, standard operating procedure or something. I think, frankly speaking, it's an embarrassment. Surely a year from now, we must have rules. Now I'll come to the sour grapes part in a moment. But the real reason for rules is this. The manner in which we function as a society, if there are rules which are to some extent hardwired, obviously they will be experimental at some level, it will force us to think and change. If it is with phases, it will compel us to adopt, and we will come towards those solutions, but not on some SOP, which is, apart from the mispronunciation, which I hope I didn't do, you have situations over here where you don't know the temporal life of that particular SOP, 6 weeks, 8 weeks, something else will get substituted. So let us make an effort to frame rules which address these concerns and which also have an amendment mechanism by which they can respond to situations as they come along in terms of practice circulars, etc., which can be issued by court registries as we move. If we get those rules, we will know that this is for some time to endure, and all of us, including our bar associations, will shift and move to that direction. All right, let me not make this a mystery, but in May 2020, out of considerable enthusiasm, my chamber colleagues and I drafted a set of rules, and we said that we have to push this out, and it was grandly called, and I have them over here. It had an explanatory note and whatnot. Supreme Court into brackets COVID-19 pandemic close bracket emergency procedure rules 2020. And not only did we draft it, we had an explanatory statement to it. We had all sorts of cross-references with hyperlinks to what was happening all across the world, etc. And we had a statement of objects and reasons. And of course, we sort of published it up in the live law with a view to engender debate. I think everyone was so completely bludgeoned by the pandemic that there was no response to it, or they dismissed it out of hand, as often happens to my submissions. So then I thought, let me do something sneaky and, forward it to some members, bar judges whom I knew were on the bench in the Supreme Court. But I think the month of May 2020, it was so early that this sort of went into the recycling bin or wherever, or whatever the learned judges use. I think I see a huge amount of opportunity also in terms of using virtual courts. I think trial courts has already been emphasized, this witness part. And I thought that video clip which Justice Ramasubramanian played was so revealing. I mean, of witness intimidation, etc. I mean, it's anecdotal, but it tells you this huge world over there and the comfort which a court and physical hearing extends. But I think in specialist tribunals, I think in terms of arbitration, I mean, which obviously supplements our virtual courts, there is much to be said and much to be commended in terms of virtual hearings. I've mentioned, of course, the durability of rules and how that will help us all as members of the bar and others to make that mental shift. I want to end with just 2 points. I think it's also time before we move to these particular adapting new technologies to remind ourselves as to what our core values are. Because robotic courts is one thing, but I think robotic justice may be a little bit of a problem, at least for someone like me. The notion, therefore, may have to be, as we move and as we respond to these new technologies, that what are the core values that we just do not want? Because I like the last part which Justice Muralidhar said. He said that perhaps we shouldn't be looking for replicating the physical courtroom. I agree with that. Let's not try and replicate everything. There's a lot which is not so great about, our present system. Let us try and, of course, improve it, but let us identify these particular values in terms of which must be there, a fair and adequate hearing in whatever manner, trial, appellate, constitutional, the preservation of integrity of the process, the ensuring that there's financial efficiency, because that's the most important thing from the litigant's point of view. The fact that in our system, justice delivery is a huge team effort. Let us never discount the fact that it's an enormous team effort in trying to ensure that at the end of the day, justice is done, which is such an important value. I'll end with just another assignment for all these dynamic gentlemen and ladies in Khanna Foundation. I think the pandemic has provided us with an enormous opportunity to somehow address our arrears problem. And maybe combining virtual courts and the new technologies and the fact that young lawyers at the bar, etc., are in need for openings and opportunities at a time like this, maybe the time has come when we attack using all this young blood with some vision and these technologies are huge pendency problem. Thank you all very, very much. It's been a privilege to serve, to address all of you and to serve on this panel. Thank you.
Thank you, sir. It was a very delightful address.
Good afternoon, Honorable Justice Ramasubramanian, Honorable Justice Muralidhar, Mr. Neeraj Kishan, Senior Advocate, Mr. Shyam Diwan, Senior Advocate, Professor Dr. Poonam Saxena, Vice Chancellor, National Law University, Jodhpur, Professor Shanta Kumar, Director, Gandhinagar National Law University, our esteemed effort partners, members and student volunteers of the Khanna Foundation, ladies and gentlemen. As we express our gratitude, we must never forget that the highest appreciation is not to utter words, but to live by them. It is with these inspiring words of John F. Kennedy that I, on behalf of the Khanna Foundation, extend our deepest gratitude to all our speakers for sparing time out of their busy schedule to enlighten and motivate us today. I am sure that our young listeners have been greatly stimulated by our illustrious panelists. Our first eminent panelist, Honorable Justice Ramasubramanian, started the interaction with the Parliamentary Committee report, which emphasized on the distinction between the virtual courts and online courts and the challenges recorded by the committee, such as access divide, connectivity divide, and skill divide, and concluded by giving a bird's eye view of the various systems adopted by different countries, such as the PEXIP Infinity application, China's compulsory similar case search and reporting mechanism, robo-courts, etc. Honorable Justice Muralidhar began the address by highlighting the importance of body language and how crucial eye contact or a shrug is while presenting a case. Your Lordship shared the experience of using video conferencing and how it has helped in certain cases, such as recording the statements of official witnesses, but has been a challenge in other aspects. Your Lordship has adopted the new technology in a big way and has encouraged all of us to accept and change this technology. Mr. Neeraj Kishan Kaul highlighted the idea of virtual courts and how they have become more viable. While virtual courts promote access to justice, there are certainly many challenges associated with it, such as a nationwide standard that is required to address the problem of recording evidence so that trials can proceed. In district courts, using Wi-Fi in place of hotspots so that every court is more accessible to everyone. Lack of reliable high-speed internet, etc. Mr. Shyam Diwan paid tribute to Justice H.R. Khanna and how his legacy has motivated and encouraged the bar. Looking at virtual courts in a broader context and how our roles are changing with this change in technology and using artificial intelligence to make sure that justice is easier and cheaper. The role of highlighting that the role of bar associations is extremely crucial in this time where technology is changing. And the importance of access to justice, especially to junior members of the bar who require to attend the court and understand the mechanisms of how to argue a case and present their matters. At this stage, we must express our appreciation to our effort partners, Hemant Sahai Associates, Lakshmi Kumar and Sridharan Attorneys, Legal Edge, SCC Online, EBC Book Company, and Mansarovar Global University, whose prompt and unflinching confidence in us has enabled us to further our cause. I must specifically thank Mr. Sumit Malik, Director, EBC Group of Companies, whose constant patronage and impetus has made this event possible. We are equally grateful to Professor Poonam Saxena, Vice Chancellor, National Law University, Jodhpur, and Professor Shanta Kumar, Director, Gandhinagar National University, who have been a pillar of support and a constant source of encouragement for us. Last but not the least, this event could not have been possible without the innumerable hours put in by our student volunteers. I take this opportunity to thank each and every one of them who have worked with great dedication and perseverance to make this symposium a success. Thank you.
So with a note of gratitude to one and all of you, we'll be ending this meeting now. Thank you.
Thank you very much. Thank you.
So Siddharth, if you can switch off the recording, I would like to share a very interesting episode with Mr. Neeraj and Shyam Diwan.
Just give me 30 seconds. Just give me 30 seconds.
I don't want it to be recorded.
You want a live streaming
defamation case.
Live
I don't want to face a defamation case.
So just give me 30 seconds.
Yes, yes.
Aditi.